Hi everyone, this is Keith Pabian from Pabian Law. Today we're going to talk about the pros and cons of filing for out-of-country workers. So at the end of the H-2B visa petition process, the final step of the whole thing, clients have the choice to either file for out-of-country workers, meaning those that are outside the country, or to file for workers that are inside the United States with H-2B visas, which we call in-country workers. Next week, I'm going to talk about the pros and cons of filing for those workers that are in country. But for today, we're going to talk about out-of-country workers. So there's some pros and there's some cons to going down this road. In terms of the positives, it's an easier petition process for clients. When we're going through the process, we file for what's called unnamed workers, meaning that we don't have to tell the federal government, we don't have to tell U.S. Citizenship and Immigration Services, which is the agency that finally reviews H-2B petitions at the last step, who the workers are. Instead, we say that a client needs 10 housekeepers, 6 servers, 4 grounds personnel, it doesn't matter. Whatever type of role that the client is applying for, we file for unnamed workers. And so from the client side, the client doesn't have to gather all of the documents to prove who the worker is, that they qualify, that they're eligible for the H-2B visa, and so on. Again, we just file as unnamed. The other thing is if a worker gets denied at a consulate or embassy when they go in for their visa issuance, which is the final step of the process that the workers have to do before coming into the country, the organization, the employer, can substitute other people in as long as that worker never got the visa issued. So again, if someone gets denied, you can substitute someone in. The other thing is, and a reason why a lot of our clients file for out-of-country workers, is it also opens up the opportunity to bring back some really long-term workers that want to go home, see their family, and then come back year after year. So again, a lot of positives, a lot of real good reasons to do it. On the other side of things, there are some drawbacks, there are some cons. Number one is there's a lot of uncertainty. There is a strict numerical cap in terms of how many out-of-country workers are allowed in the country each year, which the odds are getting lower and lower each year in terms of being able to get them in through the initial cap. The government generally adds more visas through this thing called the supplemental cap, but every year they have to do it, and it's very uncertain in terms of timing, what the government's going to do, and so on. So whenever an organization is filing for out-of-country workers, it immediately brings in uncertainty, and that's now true for both summer and winter organizations. Additionally, it's a longer process, and it does have its own level of uncertainty, even if the client is able to get out-of-country workers through the cap. The workers at the end, they have to go into the consulate or embassy in their home country to get their visa issued, and then they have to come into the United States. Both at the consulate and embassy and when they're coming into the United States, those are areas where the worker can get denied and either denied the visa or denied entry. And in this political climate, there's been more and more barriers to entry added in terms of additional vetting, additional requirements that the workers have to overcome. Also, by the time that they get here, it does pose a longer process, even if everything goes really well. Because in order to go into the consulate or embassy, the petition has to first be approved by U.S. Citizenship and Immigration Services. Then the worker has to schedule an appointment, they have to go in, then they have to wait to get their passport back before they come in. For in-country workers, there's this whole process where as long as the start date has happened, the workers can start upon petition receipt with U.S. Citizenship and Immigration Services. So again, there are pros, there are cons. It's really important that employers filing for H-2B visas understand the landscape for both of these things. And I always say to clients, there's no right answer. It's just understanding what options exist and what are right for each one of you. As always, please do not hesitate to reach out if we can answer any questions. You can learn more about us at www.pabianlaw.com. Thanks so much, everyone, and take care.